Hello friends, Mandar here. I'm back with another video. Today we are going to talk about certain scenarios for the H1B Cap petition. It is H1B Cap petition season. Your deadline is March 1st and I would like to talk about some specific scenarios. I'll also talk about the USCIS alert that has come in relation to the same alert that they posted a few weeks back. We'll go into the details of that, what it means to you. So if you are interested in this topic, watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. So let's first talk about the FY 2023 H1B Cap initial registration period, which starts on March 1st, which is just few days from now. So now a lot of people who are here, or a lot of students I should say, who are here on F1 visa, so they have completed their studies, they may have already started working for some company on their OPT. So they get first year OPT, and then if you have STEM, they get 2 more years of extension for OPT, so 3 years in total. So during this time, they can still work for that employer on OPT, but beyond that, their OPT cannot be extended. Now that is the time when they need to apply for certain visa. Now this visa is typically H1B visa, and that is the lottery process, as you all know. So every year USCIS opens up the lottery by 1st of March. They allow it to run for, they allow people to submit their applications for certain weeks, and then they get enough applicants, and then they close the process, and then they go through the selection, and they go through the running the lottery selection, then letting the candidates know if they have been selected in order to submit a full application. So now while doing this process, some people find themselves stranded because they don't get selected in the first year's lottery. In that case, what their options are to apply in the next year or the next year. So you have 3 years of OPT, so you apply in the first year for H1B, you apply in the second year, and you apply in the third year, and hopefully your petition gets selected and approved. So that is the hope. Anyways, most people are lucky to get their visas in the first year itself, but some people are not so lucky. Now traditionally there have been 20,000 separate visas allocated for master's graduate in the US, and then there were 65,000 visas available for the rest of the categories. So your chances, if you are a master's graduate, increase highly in order to secure a H1B Cap petition approval. But then USCIS does not limit people to apply for H1B Cap petitions. So basically what people do is, in order to increase your chances, what you do, you apply multiple petitions. Isn't it just like a lottery ticket? So in order to win a lottery and in order to increase your chance of winning a lottery, you typically buy more than one ticket. So if you buy 10, 20, 30, 50, 100, your chances or probability of winning a lottery are significantly higher than if you would just buy one ticket. Exactly the same applies for H1B. Now USCIS does prevent people from applying multiple cap petitions through the same employer. So say for instance you are working for an employer and you are in a software developer role. Now your employer has to apply only one petition, or is allowed to apply for only one petition for you for this H1B cap subject petition. They cannot be applying for multiple petitions for the same candidate. That will disqualify you. USCIS has clearly mentioned on their site multiple or duplicate filings. Petitioners may not file multiple or duplicate H1B petitions for the same beneficiary. To ensure fair and orderly distribution of available H1B visas, we will deny or revoke multiple or duplicate petitions filed by an employer, including its related entities, for the same H1B worker, and will not refund filing fees. Multiple or duplicate petitions will be denied or revoked even if they are filed pursuant to a selected registration. So USCIS clearly disqualifies people who are applying multiple H1B Cap petitions through their single employer. Now where the ambiguity is USCIS has not said anything about if you can apply for multiple H1B cap exempt petitions through multiple employer. Say there is employer 1, employer 2, employer 3, and you may be working for one single employer and that employer may file your H1B cap exempt petition, that is one, but you may also reach out to employer 2 and 3. In some instances you may also be willing to pick up the cost of the H1B, which is illegal by the way, but you may manage to convince the employer 2 and employer 3 to apply for your cap subject petition. Now you have 3 applications instead of 1 for the single candidate. Now your chances of your application getting picked up increases dramatically. But here's the thing, can you really do this? Yes, technically you can apply for multiple cap subject petitions through different employers, not through the same, but through different employers. But what are the ramifications? Now think about it, one from the legality perspective. USCIS has not made it explicitly clear whether or not you can file through multiple employers. So they have left that ambiguous. So now what it means is you can apply. The second question is it ethical? Now let's get the ethics out of it. From the system standpoint, yes, it is not ethical because now there are only certain 65,000 visas available and 20,000 visas available for masters. So in total 85,000. Now if you are applying through multiple employers, you are basically taking up spaces. So say for instance USCIS picks up 20% or 50% more applicants. So they have the set number of applicants that they will select for the first round, where they will allow the people to go to the second round for full filing of the H1B. Now you are taking away the chances of other candidates in order to move your case forward. That is from the ethics perspective. But every situation is different. You may be a very highly qualified student with exceptional abilities and you want to get that visa because you want to stay in US. So you would think that from your perspective it is very fair, because USCIS hasn't said explicitly that you cannot, so you go through multiple employers and apply for your petition. So that is from your perspective. Now what will happen from the USCIS's perspective? They haven't said explicitly you can't apply, but when it comes to actual selection, you may get through the first round, your application may even get selected. But when you go through the second round, when you do the full application, will you be doing it from one employer who you are actually working with, or through all the 3 employers? Possibly all 3 employers, because now you want to get it approved, right? So once all the 3 applications go to USCIS for review, they will look at it and say, okay, are you working for 3 consecutive employers? Is that even possible? You are saying that you are full-time employer, full-time software developers with one company, and so with the other 2 companies. How is that possible? At their discretion, they may deny your case. And if that denial occurs, that will be a bad stamp on your USCIS profile history for the rest of the time. The reason is because then in future, whenever you have the second round of H1B extensions, transfers, green card process, every time this situation will come up, because USCIS is able to view your history and will be able to pinpoint that you had done something that was unethical or that did not make sense. So think about it before applying through multiple channels, really what you're doing. If you are in the first year, maybe it's not worthwhile to apply through multiple channels. If you are in the second year, I wouldn't say. Maybe even if you are in your third year, you might want to take that risk, and that's totally up to you. Now talk to your lawyer, see what they suggest, and let me know in the comment section below what are your thoughts regarding multiple H1B petitions made through different employers just to get through the lottery. Let me know in the comment section below. Now let's move on to the next topic. Now you may remember last month USCIS made an alert or released a policy alert stating that there are exceptionally high number of visa numbers available in the EB1 and EB2 category, and whoever is eligible should upgrade their petition to EB2 or EB1 category. So that was last month. Now on 18th or on Friday, they released another alert reiterating the same thing. So I'm just going to read it out for you and see and then we can talk about what it means for you. And there is one particular question I'm getting a lot, and I will be providing my thoughts on that question. So let's look at what it says. It says USCIS urges eligible applicants to switch employment based categories. Now this is unprecedented. They have never done this in the past, but they are explicitly doing it now. USCIS encourages eligible applicants to consider requesting to transfer the underlying basis of their adjustment of status to first preference or second preference, as there are exceptionally high number of employment-based visas available in these categories during this fiscal year. So basically, since from October 2021 to September of 2022, there are almost double the number of visas. So they are saying overall employment-based limits for fiscal year 22 is approximately twice as high as usual, because there was spillover of about 140,000 visas from FB category to EB category last year. So you essentially have 280,000 visas available in the EB1 and EB2 category. Now also what they say is, in addition, under the relevant statute, any visas not required in the fifth preference category are made available in the first preference category, and any visas not required in the first employment based preference category are made available in the second preference based category. So basically they are saying any unused visas from EB5 spill over to EB1. Then if EB1 is used up, they are already current, so they may not need extra visas, so they all fall to EB2. Now here's interesting what they say next. These visas cannot be made available to applicants in the third preference category because, given the significant number of non-citizens awaiting visas in the second preference category, these visas are required by statute to be used for the second preference category. Now that is the most important part. They are saying that unused from EB2 will not be spilled over to EB3. So essentially, who does this impact to? This impacts anybody who were already in EB2 but they downgraded to EB3. Now if they still qualify for EB2, USCIS is saying upgrade your petition to EB2. Now there are two conditions to meet for this upgrade, and that was covered in the previous alert, is that your EB2 application or I-140 should be approved or at least pending, and then the second condition is your date should be current. So date should be current in the sense your final action date should be current, only then they can pick up the application to assign you a visa number. But technically, since they are allowing you to use filing date chart, you may be able to upgrade or interfile using filing date chart, but then it doesn't make sense because your application is not going to go anywhere until it becomes current in FAD. So really your date should be current in final action date chart. So here is the question. So some people say, okay, this is unprecedented. We have never heard this in the past. And what happened to all that talk about in the last year? So I will set that apart. But here's the question. Why don't they just progress EB2 dates, filing dates and final action dates just by a few years ahead? If they have exceptionally high number of visas available for that category, they could just progress the dates, right? They could just progress the filing dates and the final action dates, but they are not doing so. Here's what I think why not. They have been progressing, by the way. Their filing dates have been progressing every other month if you see in this chart, but why they are not progressing them rapidly to use up these? Because they know that a lot of people who were in the EB2 queue had downgraded and now they are stuck in EB3. So there are people with earlier priority dates, say 2010, 2011, 2012, 13, who are stuck in EB3. They want those people to come back to EB2 queue and use up those visa numbers. The reason they are not progressing the dates just to get the more applicants, in my mind, I would give preference to people with earlier priority date who are stuck in EB3 than just progressing the dates to 2014 and 2015. So that is just my logic. So I got a lot of questions on this particular one, so I thought I would clarify that. So here's what I want to wrap up with. If you are eligible for an upgrade to EB2 based on the conditions that I mentioned, go ahead and upgrade. Another thing to note is if you are already current in EB3, there is not a lot of sense to upgrade to EB2 because you already have, technically you have a visa number available now in EB3 because your date is current. It's just the processing that is delayed. So consider that aspect before you upgrade. Another thing is we don't know how they are going to handle all these cases from the one single point of contact in California. So that is not clear. So If you are on the borderline, I would say wait for a couple of months before you upgrade, maybe 1 or 2 months. Don't wait too much because this is only available until end of September. There is certainly a push by USCIS to use up all these numbers. Whether or not they are able to do so is to be seen. The last thing you want to do is you upgrade, you are current in EB3 and you upgrade to EB2 and then EB2 retrogresses in October. That is the last thing you want to do, and that's where I'm talking that from the past, from the history, because we saw what happened to EB3 category last year. So do what feels best to you. If you want to reach out to me for my opinion, contact me on my Patreon site and I'll be happy to provide my perspective. So that's all I had in this video. If you like the content of this video, please hit the like button and consider subscribing to my channel, and I'll see you in the next one.